everyone. Thanks for joining us today. On behalf of the Sandbox Center team, welcome to our Experts in Residence session, the legal brief with Barriston Law, and welcome to September. It's crazy to say that. I was just saying that to Justin, but we're trying to hold on to summer just a little bit longer, the weather at least, but we're ready for some change, or we're ready for some new stuff. So thank you for joining us.
Thanks, Mackenzie, and thanks everybody for attending our Experts in Residence at the Sandbox. I am an employment law lawyer at Barriston LLP in Barrie. I work often out of our Collingwood office, especially since the pandemic has hit, and I live here in Collingwood. Today we're going to talk about one case in particular from the Ontario Court of Appeal. This presentation does not constitute legal advice, so we're just providing you with some general information here. And I know many of you will probably have some questions and we can generally answer them. But if you do have a specific situation that you require assistance with, you'll have to reach out to a lawyer. Ideally, you can call me and I can help answer your questions. So I'm just going to establish a couple of the basics early here so that you'll have an understanding of what this case is about and what we're going to talk about. So the Employment Standards Act is a big piece of legislation applicable to employees and employers in Ontario. And what the legislation does, in effect, is create a whole bunch of minimum standards that employers need to comply with. Most of the obligations are on employers. There's some obligations on employees as well in the Act, but the vast majority of it is on employers. And so things like minimum wage, for example, are set out in the Employment Standards Act. Things like vacation, right? So generally, everybody or most employees in Ontario are entitled to 2 weeks of vacation at a minimum, and sometimes in some circumstances they're entitled to 3, but after that it's up to employers if they would like to decide to offer more than the Employment Standards Act. So some lucky folks have 4 or 5 weeks of vacation, and employers choose to do that because they want to retain staff and they want to have happy employees, right? So certainly employers can choose to give you more than what the requirements of the ESA are, but they cannot give you less. And an important provision of the Employment Standards Act is that employers cannot contract with an employee to provide something less than the ESA, right? So typically the law of contract allows 2 people to come together and agree to any sort of arrangement, any sort of commercial transaction or any sort of business partnership, right? But one thing that employers cannot do is agree with an employee to pay them less than the Employment Standards Act. So, if someone was really desperate for a job, they might be willing to accept less than minimum wage, but that is illegal in Ontario. So that is the basic premise that sort of gives rise to this case. What sometimes happens is if an employer contracts with an employee in writing and a portion of that contract does not comply with the ESA, the court will essentially throw the employment contract in the shredder. So let's see how that happens. This is Waxdale versus Segwan North America Incorporated. The appeal decision from the Ontario Court of Appeal came out a couple months ago, I believe now. So what happened here was an employee of Waxdale was terminated. He was a director of sales. He was not employed for very long. I think he was employed for right around 8 months. And his yearly compensation was supposed to be around $200,000 after bonuses. And he signed an employment agreement. So the employment agreement had two important termination clauses. One of the clauses said, essentially, of course, I'm going to paraphrase, if we terminate you without cause, the only thing we're going to owe you is the minimum amount required to be paid under the Employment Standards Act. And this is a common thing that employment law lawyers do, right? So if you come to us as an employer, we will draft an employment agreement that will allow you to do this, right? So at the end of the day, if you fire somebody, you're going to owe them money unless you have cause, and you can limit the amount you're going to pay, right? So that's what they attempted to do. They said, if we terminate you without cause, we'll pay you the minimum under the ESA. And then there was a second clause. And in the second clause, the employer said, if we terminate you for just cause, we do not owe you anything. And then the employer set out a bunch of circumstances that it considered to be just cause for termination. So the main overarching question in the trial court was, if the, well, I should clarify something. The employer admitted that the just cause provision violated the ESA, okay? So the question the court had to decide was, if the just cause provision was void, does that mean the rest of the agreement is also void? So I just want to clarify why exactly the employer admitted that their just cause clause, that's a bit of a tongue twister, was void. Basically, the ESA allows an employer to terminate an employee without termination pay or notice of termination if the employee is guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. So in general, at first glance, this might seem relatively easy threshold, right? Oh, disobedience and I can terminate this person and not pay them anything? Okay, easy. But unfortunately, you need to read the clause as a whole, and it becomes quite a difficult standard to meet. So number one, the person needs to be guilty. So that would mean you need to have lots of proof. Number two, it would need to be willful. So the employee would need to know that they're doing something wrong. They might disobey something that you want them to do, and they had no idea that that was not allowed in the workplace, right? So it has to be willful, and it cannot be trivial, right? Which is just a massive gray area in and of itself. What is trivial and what is not? And it cannot be condoned by the employer. So the employer can't just stand by and let the employee be late to work every day or something like that, right? You have to consistently discipline the employee. So if your termination for just cause provision were to say something that does not meet that requirement under the ESA, then that just cause provision would be void, right? So for example, if you said, I can terminate you if you're late for work 3 times, and I can terminate you for just cause and not pay you anything. Arguably, that wouldn't meet the standard required by the ESA, and therefore arguably would contract out of the ESA. So here, the employer didn't even put up a fight. They just said, listen, we're agreeing that the just cause termination provision is void. So let's talk about the clause that we want to enforce, which is our clause that says, when we terminate you, we're only going to pay you the minimum ESA amount. So they went to trial, And there's two different decisions we're going to talk about here, right? So first was the original trial decision, which was technically not a trial. It was a motion for summary judgment. It's a little bit different, but it was a final determination of the case. And the employer's counsel said, listen, sure, the just cause provision is void, but we have this other clause here that says he's only going to get the minimum when we fire him, and that clause should stand up. And the trial judge agreed here. So I've quoted the decision on this slide, and here the judge says, the defendant has acted within its rights under the agreement. It has paid the plaintiff 2 weeks severance pay plus his applicable car allowance. That is considerably less than what the plaintiff would be entitled to at common law, but is more than the bare minimum under the ESA. It complies precisely with the defendant's obligations under the termination of employment with notice clause. The plaintiff has been paid in full under a valid and enforceable clause in the agreement. Accordingly, there is no genuine issue for trial and the action is dismissed. Okay. So of course, we have the employee appealing this decision, and we have the Court of Appeal, which quite frankly, in 95% of cases is the last line of defense, right? Or is the last word, I should say, from the courts. If you want to pay to go to the Court of Appeal and hear what they have to say, their decision will very likely be the last decision of the court. The only other option is the Supreme Court of Canada, of course, and they only take very, very specific cases. So essentially, when the Court of Appeal issues something on Ontario law, that's going to be that. So here we have the Court of Appeal disagreeing, okay? And the basis of their disagreement is essentially when employers draft employment agreements, at any portion of them, if any part of the agreement doesn't comply with the ESA, then the rest of the termination provisions can be tossed out. And the reason for that is, and you'll see the quote here, employers will have little incentive to draft legal and enforceable termination clauses at the beginning of the employment relationship, right? So if an employer can simply draft an agreement that states a number of onerous provisions for the employee, but has one clause that states, well, we will pay you the minimums no matter what happens. The courts do not like that behavior because it incentivizes the employer to draft onerous provisions, right? And then they can just show up to court and say, well, regardless of all these onerous provisions, we were still going to provide the minimum, and that complies, right? And they don't like that because in general, the employment relationships, there's always an imbalance of power, right, between an employer and an employee. Employees are at a major disadvantage because they, of course, want a job and they want to make some money for their family. And so in general, people just accept what is given to them in most cases. So this second paragraph here on this slide is also important, right? An employment agreement has to be interpreted as a whole. You cannot just look at one sentence and make a determination. You have to read the entire agreement and see if it violates the ESA. And here they talk about the power imbalance and restricting the employee's right to common law termination pay, which if you did not know is much greater than the Employment Standards Act minimums. Okay, so that's what this whole battle is really about. It's about increased compensation under the common law. So we have a last ditch effort by the employer. They say, wait a second, we have a clause in our contract, and the clause states if any agreement in this contract is considered void, then a court can sever that specific clause. So they can essentially just take that clause, remove it, and every other clause shall remain in effect. And the court said, absolutely not. We're not going to fall for that trick. And they state a severability clause cannot have any effect on clauses of a contract that have been made void by statute. So statute in this situation being the Employment Standards Act. So for example, you can have a severability clause for something under the common law that would allow you to remove a specific clause and have the remainder of the agreement stand. But if the clause is void according to some sort of statute, even a one that is not the Employment Standards Act, you cannot sever it. Okay. So what's the lesson to be learned here? Of course, you need to carefully draft your employment agreements. Lawyers have been sort of battling for the past decade with the courts about how exactly you can appropriately limit compensation on a termination. And plaintiff lawyers, right, including us sometimes we act for employees and sometimes we act for employers. You can get very, very creative in finding a small anomaly that may not comply with the ESA and attempt to void the employment agreement. And so you do need to ensure that your employment agreement complies with the ESA, because essentially what happened in that case, just to wrap up the case itself, is the court said, okay, this entire termination clause essentially is void. And as such, rather than the minimums under the Employment Standards Act, the employee is owed termination pay pursuant to the common law, which means quite a bit more money for the employee. And the court allowed the parties to go home and settle the matter themselves. And they didn't issue any direction on what was owed. So again, in this specific case, the part of the contract that was void was the just cause provision. So here, it's a little bit scary for employers, because essentially what this case stands for is that even if there's a provision that is sort of entirely separate from your valid termination clause, the court could very well throw out the entire agreement, right? So it remains to be seen. Currently, it appears that the court is limiting it to termination clauses specifically. So any of the clauses about termination, whether it be for cause, without cause, what kind of pay is going to be owed, etc., any of those types of clauses will be examined in great detail. But certainly plaintiff lawyers will attempt to expand the scope of these types of decisions and say, for example, if there's something in the vacation pay section of the employment agreement that does not comply with the ESA, they can attempt to make an argument that the entire agreement would be thrown out. Now, I imagine that'd be quite a difficult argument to make, but like I say, anything for plaintiff lawyers for litigation fodder will create difficulties for employers. So at the end of the day, if you do have employment agreements, they may need to be updated depending on their wording. So
we can get to our first question here, Justin. somebody's asking, I guess there's two questions in one. Can the employer invoke the force majeure criteria to terminate your contracts now that COVID-19 is not an unpredictable event? And then the second part of that, what would be other reasons that the employer may invoke to terminate the contract?
Force majeure. The first thing you need to know is that force majeure does not exist outside of a contract. And by that, I mean, you need to have an agreement with your employee that specifically states, in the event of some sort of force majeure, including but not limited to a pandemic or a earthquake, or, I'm just sort of going off the top of my head here of what a sort of force majeure clause sounds like. If you don't have an agreement with your employee that you can terminate them as a result of a force majeure event, then you're not going to be able to rely on force majeure. You can attempt to rely on frustration of contract, which is quite difficult to do. The frustration of contract would essentially mean that the contract is impossible to perform. So realistically, I find it very hard to think of a situation in an employment contract where frustration would actually apply. It would have to be, for example, if you had an employment contract to work on a very specific shrimp boat for 2 weeks, and the shrimp boat caught fire and sunk, then the employer could argue, well, this contract is frustrated because it's impossible to perform. The boat does no longer exists, right? Whereas other folks, perhaps you own a restaurant, right, and your business has been decimated from the pandemic. Of course, financially, it may make it impossible or illogical to run your business, but it does not make it impossible to perform the employment contract. You could choose to still start making pizza pies or what have you. So let me get to the second part of that question. What would be the other reasons that the employer may invoke to terminate the contract? Okay, so the only other thing you can do is terminate for just cause. And perhaps this commenter has a misunderstanding. So just to be clear, employers, if you do not have unionized employees, you can fire them at any time. The issue is what you're going to owe them for termination pay. And that depends on many, many different factors, right? So for example, if you were to fire a pregnant woman, I mean, you can go ahead and do that, but you're going to have lawyers coming after you for a heck of a lot of money. So this is sort of why, so again, you can fire anybody you like. You don't need a reason. It's just a without cause termination. But if you wanted to fire them and not pay them, then you need just cause, right? Which is very difficult to achieve. There needs to be some sort of significant misconduct, right? Like nearing a criminal level or stealing from the employer or something like that for you to terminate for cause, or consistent discipline and no improvement from the employee. So yeah, I think that question is answered.
Do you want to give people listening just a quick reminder of what force majeure is?
Yeah, so force majeure, right? Sometimes in large, significant commercial contracts, these types of clauses are more common, really. They're pretty uncommon in most employment contracts, I would say. But if you have a large commercial contract, right, for let's say consistent delivery of grain every 3 months, you're going to ship us 10,000 tons of grain or something like that. That contract might have a force majeure clause, which says if any of these uncontrollable events occur, then performance under this contract is suspended until such time as, the parties agree that performance should continue or something along those lines. So this commenter is attempting to say that, the pandemic is a force majeure event, which it definitely, or it certainly can be argued that it is for many parties, depending on the wordings of their respective contracts.
Right.
But if you do not have an employment contract that specifically has a force majeure clause, you cannot sort of just conjure it out of thin air, which is what you can do with frustration.
Oh, okay, gotcha. So we'll move on to the next question. What if there is no termination clause in an employment contract?
So if there's no termination clause, you're going to owe termination pay according to the common law. Now, what we typically advise is that at a minimum, you always need to pay the Employment Standards Act minimum, right? And you're not going to get in any trouble for paying the ESA minimum. And if the employee agrees and walks away, then great. If they go and speak to a lawyer, they're likely going to come back and ask for more money, because if there's no termination clause in the contract, that means you're going to owe notice or pay in lieu of notice pursuant to the common law, which is generally more money.
Next question we have, what organization can lobby on behalf of employers affected by undue hardship as a result of the pandemic?
Good question. I recently read an article about a number of restaurants. A lot of them were big franchise corporations that were all coming together to lobby the government. In a quick Google search, you might be able to find it. I know one of the franchises was Boston Pizza. That's just sort of like a special interest group. I don't remember the name of the organization. I think they're sort of just drafting up a letter together to the provincial and federal governments, attempting to get relief. Outside of that, I mean, I can't think of a specific organization that can lobby on behalf of employers. Realistically, right, employers, it's a very large group of people, large group of corporations and organizations. So you'd have to sort of, I think you'd have to sort of get a groundswell movement going yourself.
The next question we have, are probationary clauses necessary?
No, not at all. So probationary clauses are nice. If I was an employer, I would want to put them in. And the reason why is because you cannot have a probationary period if the employee doesn't agree to it in a contract. So you need to have a contract that says you're on probation, and pursuant to the ESA, you can terminate somebody anytime in that initial probationary period, and you don't owe them anything. So if you hire an employee and they're completely useless, you can just fire them. I'm sounding a bit callous here, but this is the reality of the situation, right? This gives the employer an out to terminate somebody without providing any notice or pay in lieu of notice. So they're not necessary, but I would recommend them if you're an employer.
Should agreements have just cause and not for cause? Question mark?
Yes, I would say the answer to this question is yes. And you're going to want a clause. Of course, we just talked about this. You're going to want a just cause provision that says, well, to be clear, you're going to want a termination clause that states we can terminate you without termination pay if, and then you'll basically copy and paste the exact wording of the ESA, that willful misconduct sentence. That's exactly what you're going to want to say, right? Because you don't want to contract out of the ESA. So you can say, we'll terminate you if willful misconduct that is not condoned, etc., whatever that sentence was, right?
Okay.
And then you're going to have a second clause that says we can also terminate you at any time without cause, and when we do, we're only going to pay you the minimum ESA amounts, right? And of course, I'm paraphrasing right now. The entire point of this presentation is that you need lawyers to draft these things properly so that they hold up.
And you got your bases covered.
Yeah.
Perfect. Second, or another question we have here is somebody's asking, how is an intern working part-time viewed in Ontario? Does an employer have any responsibility to the intern in terms of wages, or can the intern work part-time for free? I don't know. I don't know if that has to do with like our conversation, but if you could provide some knowledge, that would be great.
Yeah, I mean, I would say, like, to be honest, I'd have to research this to provide you a definitive answer. But to cover my bases, I would say that I don't think anybody can work for free, and that at the very minimum, you're going to be liable for a claim for unpaid wages, which means minimum wage, vacation pay, etc. So I would say I don't think anybody can work for free. But of course, I recall, a few years ago, unpaid internships was a big deal, and
yeah, I know. Even for I remember back in college, for me, I had to do it was unpaid internship for me. But obviously, there's got to be an agreement somehow from like the institution with the employer, right? So
yeah, like to be honest, I'd have to, like I say, these things change pretty regularly, and so there might be some very specific circumstances where people can work for free.
Mm-hmm.
But I imagine if that is the case, you'd need a quite clear employment agreement setting out what was happening.
For sure.
Otherwise, there is liability for unpaid wages. There's a famous, or not famous, but quite significant news event too, is when all these junior hockey players started a class action for unpaid wages because they were attempting to say that they were employees. And you can do a quick Google and read about that. But long and short of it was they eventually added an exemption directly into the Employment Standards Act, clarifying that specifically junior hockey players were not, the ESA did not apply to them. So then we have this question: what happens if there's no employment agreement? This is very similar to the earlier question. If there's no employment agreement, again, the common law applies. So again, you can fire somebody at any time. It's just a matter of how much you're going to owe them, and the amount you're going to owe them is pursuant to the common law.
Perfect. What do I do if I want to give an existing employee a new employment agreement?
Okay, so there's quite a few pitfalls that can come about in this kind of a situation. Generally, if you want an employee to sign a new employment agreement, there needs to be what's called consideration for doing that. So usually that means a promotion or a raise in this context. Sometimes employees will refuse to sign an employment agreement, right? And so what you can do in that circumstance is, if you talk to a lawyer, they might advise you to say, okay, we're going to provide you notice that your current employment agreement with us is being terminated, and at the end of, and you're going to get working notice. So you're going to keep working for, say, the next 8 months or whatever the applicable time period is for that employee. And at the end of that, you'll have to sign this employment agreement. Otherwise, we're parting ways. So that's one way you can do it without paying any kind of money.
What happens if an employee does not want to sign an employment agreement?
Oh, I kind of jumped ahead and answered this one already. So
no worries.
Yeah, you can basically tell them, okay, Bobby, we're going to fire you in 12 months unless you sign, like, what you're essentially saying, our current agreement is ending in 12 months, and we're providing you working notice of that. And when the 12 months is up, you can either sign this new one or we'll part ways. And so again, the length of time depends on different factors. mainly how long the employee has been employed there.
And how do I determine if my employment contract is valid?
Well, I mean, realistically, you're going to need the help of a lawyer, I would say, to determine if any of the provisions violate the ESA. If you feel confident enough to read through and interpret the ESA, by all means, you can proceed and attempt to do that, and see if any of the provisions of your employment contract contradict or do not comply with the ESA. And that's how you'd have to determine if it was valid.
Somebody's asking, what is a cause for termination? So I'm sure there's many, but.
Yeah, we did kind of discuss this a bit. So
right.
Cause under the ESA is different than cause under the common law.
Okay.
And again, so cause under the ESA would be that willful misconduct sentence. And cause under the common law is many, many different situations. And again, like there's going to be, there's sort of two different branches. The one branch is one event that occurs where it's so significant that it appears that the employee has repudiated the relationship, the employment relationship. So, you know, if you got into, I'm trying to think of, like stealing from work is the easy one, right? If you stealing something from the employer, you can make a pretty solid case for cause. But even then, right, like if somebody came to me to see me and said, oh, my employer or my employee has been stealing printer paper, right, I would probably tell them, well, I would discipline them for that, and I do not believe that that's just cause for termination. So it does need to be some sort of significant misconduct to reach that level. And the other branch is multiple instances, right? So if this person is constantly taking printer paper from work, and you're giving them write-ups, right, and you're disciplining them for taking printer paper home, you could attempt to build a case for cause for termination.
Okay, don't take printer paper, people.
Right.
Another question, I guess, follow up to the lobbying. Why don't lawyers lobby for change on law during the pandemic?
I mean, I don't want to give my honest answer here because, yeah, I mean, here's the very harsh but real answer. Okay, the lawyers do not care what the law is, because at the end of the day, they're going to get paid no matter what the law is, right? We don't have an interest one way or the other. So, you know, I have employees that hire me and then I act for them, and then I have employers that hire me and I act for them, and I'm going to advocate hard for them, right? So that's why lawyers don't lobby for change, is because, quite frankly, I don't think they care. So if a lawyer is also an employer, I'm sure they might have an interest in it, but lawyers in general don't have an interest in what the law is.
Okay, next question. Have there been any changes made to the Canada Labour Code that resembles IDEL? And I'm not sure what that is, so if you want to explain that to me, be my guest.
Yeah, no, honestly, I can't answer this question because I'm not aware. I don't know what that acronym is, and yeah, no, I wouldn't be able to answer this question without researching it myself. So okay. Canada Labour Code, I don't deal with it nearly as often, right? It's federally regulated employees. The Canada Labour Code applies to federally regulated employees. So okay. I deal with it in some circumstances. It's often trucking companies because they're interprovincial and so they're federally regulated, but yeah, it's few and far between that I deal with the Canada Labour Code, so I can't answer that question at this time. Okay,
no problem. And the last question we have here, if anybody else wants to chime in, feel free. Oh, somebody popped up, IDL, infectious disease emergency leave. Perfect, now I know.
Oh, yeah. Yeah, I'm not aware of those changes being made to Canada Labor Code, but I cannot say definitively. So, yeah, no, I apologize. I cannot answer that question.
So the pandemic forced the closure of this person's GTA location, leaving the Barrie location as their only workplace. Is the employee deemed to have resigned if they are not willing to commute to the new location? How best would we document this?
Okay, so, you know, this person obviously is experiencing this situation themselves, right? And unfortunately, I can't broach into providing legal advice, right? Like generally, if an employer makes a change to an existing employment contract and it's substantial or material, the employee can treat that as a constructive dismissal, and then they can seek termination pay. But you are really going to want to speak with a lawyer about that, because constructive dismissal is difficult to prove. So you need to be careful about what you do. And I mean, generally, how do you document things? Well, try to get everything on an email. Avoid the telephone is what I would say.